My name is Volker Krüger from Velden-Duffey attorneys. Does the voetstoots clause always protect the seller against claims by the purchaser based on latent defects? Answer is no, and I will explain to you why I say this, with reference, amongst others, to a recent court case dealing with this question. Now, voetstoots clause is a term in the agreement which stipulates that the purchaser takes the property from the seller as it is. In other words, the purchaser accepts the property with all the defects that there might be in the property, including any latent defects. Latent defects are defects which are not visible through a normal inspection of the house, such as, for example, a leaking roof, or such as cracks in the wall which might not be visible because they are hidden behind paintings, such as the problem with the foundation of the house, or maybe a swimming pool which has cracks and is leaking water, etc. So those are all latent defects, and as a general rule, if there's a voetstoots clause, then the purchaser cannot claim damages from the seller because of those latent defects. However, there is an exception, at least one exception, to this rule, and this is where the seller was aware of the defect and fraudulently hid the defect from the purchaser, or basically caused a fraudulent misrepresentation to the purchaser about the relevant latent defects. Now, there are several court cases which have already confirmed this principle, but there's a recent decision which I would like to refer you to, namely the one of Leroux against Zitzman, where the court also had to deal with the question as to whether the voetstoots clause was in that case enforceable by the seller or not. So the facts of this case were more or less the following. The seller had been the owner of the relevant property for about 6 years. When the negotiations regarding the contract of sale were happening between the seller and the purchaser, the seller actually pointed out to the purchaser that there's a leaking roof in room number 7. And the purchaser was therefore aware of that, and he was happy with that, with the purchase price, with everything else, and the contract of sale was signed, the property was transferred, the purchaser moved in, and then the rains came. And it was not just room number 7's roof that was leaking, but all the rooms of the relevant building on the property were actually leaking and caused damages to the furniture in the room. So the purchaser sued the seller for damages because of that latent defect, and the seller, of course, raised the voetstoots clause that was contained in the agreement as a defense. By the way, I would say about 90–95% of contracts of sale of land or of houses actually have the voetstoots clause as a standard term in the agreement. So this agreement in this court case also had such as voetstoots clause contained in the document. So the purchaser then got a report from an engineer as an expert about the roof, and the evidence before the court was that this expert was of the opinion that the problem with the roof must have existed for a lengthy period of time, and that the problem with the roof could not have happened after the contract was signed in the couple of months from that time period until the rains came. So the conclusion of the expert was that probably for a couple of years there was already a problem with the roof, and that the seller must have been aware of that problem and the leaking roofs in respect of all the rooms as such. The seller denied this and said that he was not aware of the leaking roof, except for room number 7, which he of course, pointed out to the purchaser. The court then, on the facts, had to decide who to believe, and the court concluded that the seller is not telling the truth. The court concluded, based on the engineer's expert report, that the seller was indeed aware of the defect, and his explanation and the cross-examination in that respect didn't make sense. So on the facts, the purchaser managed to prove that the seller was aware of the latent defect. He was guilty of a misrepresentation because he only pointed out the problem in respect of room 7, and the purchaser consequently was successful with his action against the seller and was actually awarded damages for the repair work and also for loss of income that he suffered because of the damage caused by the leaking roof. So the message, I think, is that the voetstoots clause does not always protect the seller. It depends on the circumstance. If the purchaser can prove, which is sometimes not that easy to do, but if the purchaser can, through expert evidence or otherwise, prove that the seller was aware of the defect and that the purchaser was somehow misled into believing that there are no latent defects or that the specific latent defects do not exist, then the purchaser can still successfully claim from the seller for damages. Maybe just a final point, another exception to the rule that the voetstoots clause protects the seller against claims based on latent defects is, of course, the Consumer Protection Act. In terms of the Act, where the seller is selling the property as part of his business, such as someone who speculates in property on a regular basis, or such as, for example, a developer who's selling the house as such, then because of the Consumer Protection Act, that voetstoots clause would actually also not be enforceable by the seller.